Good afternoon. Thank you for coming today. Before I begin, I would like to ask that you hold all questions till the end because my presentation is on a time limit. And also I'd like to note that some of the information in this presentation comes from outside sources, but I've provided citations where necessary. Good afternoon. My name is Bennett. I'm a senior at Clear Falls High School. Currently, I'm enrolled in the Independent Study Mentorship Program. My teacher's name is Mrs. Robin Holt, and my mentor's name is Dr. Ann Collada. I'd like to welcome you to my website now. This documents all of my work while I've been in Independent Study Mentorship. Independent Study Mentorship, or ISM, is a junior and senior level course that allows students to explore a prospective career. And the goal of ISM is to create a final product of the collegiate or professional level. So my product was a utility patent application based off an assignment from Professor Valerie Friedrich's patent prosecution class at the University of Houston Law Center. For more information on ISM, you can access the main website here. And to see me working on the patent application, you can look at the slideshow here. A little bit more about myself. I originally enrolled in ISM because I was interested in political science. Last year, I pursued an independent study under the Social Studies Department head, and I ended up writing a policy agenda at the end of the semester. And afterwards, I wanted to continue exploring the field, but gain a legal background also, so that I could pursue it further in college and possibly a career. So that led me to contact Dr. Collada, and that's why I'm here today. For further information on my time in Independent Study Mentorship and my independent study from last year, you can access my resume online. And it's not very extensive, but I'm slowly building on it. Now, Dr. Collada's resume, of course, is much more extensive. She is a transactional intellectual property attorney and the Associate Vice President of the Office of Technology Transfer at UTMB Galveston. I am emulating her role as an intellectual property attorney, and some of her duties include buying, selling, and licensing rights to intellectual property, registering trademarks and copyrights, writing business contracts, and what I've been emulating, which is drafting a utility patent application. While she is not working, she also volunteers with the Licensing Executive Society, which is an organization of intellectual property professionals that meet quarterly to discuss current intellectual property issues. She has served as the chair-elect chair and the co-elect chair in the past 3 years, and now she is a member of the Programs Committee. Additionally, on top of all of this, she is also obtaining her Master's of Law at the University of Houston. She has already obtained her Juris Doctor, her PhD in Chemistry, and her Master's of Business Administration. So I've been throwing around the term IP, or intellectual property, around a lot. So what exactly is intellectual property? Well, for those of you who don't know, intellectual property is a legal specialization that works to protect creations of the mind. Now, there are many different types of creations of the mind, and therefore there are many different types of subfields in intellectual property law. And some of these subfields include copyright law, which copyrights work to protect expressions of an idea. And now, generally when we think of expressions of an idea, we think of things like literary works or paintings. However, Dr. Collada was telling me just the other day that copyright law is becoming increasingly technical. And I found that this, and involved with digital design and computer technology. And I found that this is very typical of IP law, and patents exemplify this. Patents is the second subfield of intellectual property law, and they work to protect inventions. Now, an invention can include an apparatus, a method, a chemical composition, or an improvement on a previous invention. the patent application that I was working on was for an apparatus. Additionally, there are trademarks and trade secrets, and trademarks work to protect commercial names and logos, whereas trade secrets work to protect confidential information that gives one company an advantage over another. Dr. Collado and I talked about Coca-Cola's trade secret, which was their secret formula, and we discussed that while they did not patent that secret formula, they could still go to court over someone using that without their permission. And while it is not a subfield, it is commercial law is closely intertwined. I'm going to bring us to our Prezi. I apologize. And the reason that commercial law is closely intertwined is because the purpose of intellectual property law is to, like I said, protect creations of the mind. And the purpose of protecting those creations is so that you can make a profit off of your creation. So for this reason, many inventors or many creators create businesses off of their intellectual property, and many businesses come out with intellectual property. And therefore, an intellectual property attorney must be well-versed in both fields. Now, intellectual property attorneys not only manage the legal side of intellectual property law, they also have to meet with clients, because like I said, the clients are ultimately the ones that are coming up with the intellectual property. I apologize, this Prezi is not coming up, and I wanted a visual for you. Okay, that's okay. And, okay, so in order to account for this other side, intellectual property attorneys must meet with their clients so that they can advise their clients on how best to protect their intellectual property and help their clients form and structure companies. In order to do this, you obviously have to become an IP attorney, and some of the requirements of an IP attorney include obtaining a Juris Doctor, which allows you to practice law, and to file and draft patents, you also have to pass the patent bar exam. Now, you can take the patent bar without becoming an intellectual property attorney, then you would be a patent agent, and patent agents can still file and draft patents, however, they cannot prosecute patent infringement, so they cannot protect patents in court. And the benefit of going to a patent agent is that they tend to have lower billing rates. However, like I said, they cannot protect the patents in court. Additionally, while these degrees are not required, a Master's of Business Administration and a Graduate Technical degree also help in the field. A Master's of Business Administration allow you to deal with the commercial side of intellectual property law, while a graduate degree, such as a PhD in chemistry or in computer science or biotechnology, will allow you to actually speak intelligently and know what you're patenting. Obviously, I don't have a Juris Doctor, and I don't have an MBA, I don't have a PhD in chemistry, and I've never taken the patent bar. So how exactly am I exploring intellectual property law? Well, like I said earlier, I drafted a utility patent application based off an assignment, and I also had to account for my client's financial resources. My client was not able to pay for more than the allotted 20 claims, which the claims are, we'll get to that in a sec, but that's a section of the patent. My client could not pay for more than one drawing, and my client could not pay for a search for prior art. For the purposes of my assignment, prior art consisted of all previous patents and publications all around the world that disclosed elements of my client's invention. This is generally a risky move in intellectual property because I don't even know if my client's invention is patentable. However, in my world, no prior art existed, which would obviously be ideal because this means that you don't have to draft your patent application around anyone else's. However, Dr. Collado and I felt that it was necessary to exclude all prior art so that I could really grasp the fundamentals of intellectual property law. So I've been discussing the patent application a lot, so I'd like to walk you through it now on how I went about drafting it. And first I would like to start off with the claims. The claims define the metes and bounds of the inventor's right to exclude. Well, exclude from what? Well, a patent application gives the patent holder the right to exclude others from making, using, selling, offering for sale, or importing into the U.S. their invention without their permission. So the claims define what constitutes this, their right to exclude. Now I'm going to demonstrate this through an exercise and kind of show you what this means. I'm going to give you a paper of my claims. And what I would like you to do is I'd like you to read the claim that is titled Claim Number 1. And then I would like you to, oh, sorry. Oh.
I just passed mine out.
Okay.
Thanks.
And I would like you to draw what you think the invention is based off of that claim. And for those and Professor Tate, I will put it up here if you can see it.
I got it.
Oh, you do? Okay, okay, good.
Yeah, I was.
And Professor Tate, since you can't see what they're all drawing what they think the invention is, and their drawings look. Their drawings consist of a wide variety. That's for sure.
Okay. Yeah, I looked at your draft patent application before.
Oh, okay. Okay, you good? Okay, it's just based off the one number 1. Oh, title.
Oh, sorry.
No, that's fine. Okay, so has everyone drawn the invention based off of claim number 1?
Yes.
Okay, so now what I'd like you to do is I'd like you to hold up the pictures and then just kind of look around the room and compare your drawings. Okay,
Wow.
that's great, that's great. So there's a wide variety, and this shows that the claims are broad. And now, the purpose of keeping the claims broad is so that the patent holder can exclude all of you from making, using, selling, offering for sale, or importing into the U.S. all those embodiments of his invention. Now, my initial draft of claims did not start off this broad. They started off much more narrow. They were very specific. Here you can see the initial draft. So the claim that you just drafted started off like this, which says a rack comprising a bar, or a rack comprising a base comprised of a first bar, a second bar, and a third bar, wherein the side of the second bar connects to the first end of the first bar. And already you can see that this is extremely specific. It tells you the number of bars, it tells you that bars exist, and then it goes about telling you even how the bars connect. If I would have given you this claim, your drawings would have looked a lot more similar, and the patent holder wouldn't have been able to exclude you from making, using, selling, or offering for sale, or importing to U.S. this breadth of his invention. So how did I go from something this narrow to something that broad? Well, I did the same exercise that you did. I drew different pictures of embodiments, and then I compared the pictures to my claims. And if I could not claim these pictures, then I knew my claims were too narrow. So then I would go back and I would draft another set of claims until I could claim each of these drawings. The next part of the patent application that I worked on was the detailed description. And the detailed description basically describes a drawing of an embodiment. And this will, well, when this pulls up, this will be the drawing. So this is just one of the embodiments of my client's invention. And the detailed description goes through and tells you how each of these different elements, which all the elements are numbered, it tells you how the different elements collaborate to create his invention. And the purpose of the detailed description, I'm waiting for it to load, is to show that the inventor is in possession of the invention. It shows that the inventor is not trying to claim everything that has a base and a frame. It shows the patent examiner that he has an idea of what exactly this invention is. The next part that I drafted of the detailed description was the brief summary. And the brief summary is basically a short statement that describes what the drawing is. So my brief summary basically said that the figure 1 depicts a rack for moving storage. And here I'm going to, now I'll pull it up. So this was the detailed description, and then this is the brief description. And then I wrote the brief summary. Now the brief summary, again, is just another description of what the invention is. And in terms of its specificity, it's medium in scope. The claims are very broad, whereas the detailed description is very specific. So I wrote those two first to establish my extremes, and then draw from both of those to help me write the brief description, which is in the middle. After, or before the brief description, is the background. And the background basically describes a problem without explicitly stating the problem. In order to patent an invention, one of the requirements is that the invention has to solve a problem in a new and non-obvious way. So I have to tell the patent examiner, or suggest to the patent examiner, what the problem is. The reason I chose not to explicitly state it is so that the patent examiner could not use an explicit problem statement against me in an obviousness rejection. So what this means is that if I were to say the problem that the invention is trying to solve is moving storage, the patent examiner could say, well, a pickup truck moves storage too, and therefore he would reject the patent application with a rejection from the auto industry. So in order to suggest the problem, instead of explicitly stating it, I say things like, there are many ways to move storage. You can push it across the floor, you can pick it up and carry it across the room, and while these ways work, they require a sufficient amount of time and a sufficient amount of energy. And in that, I have suggested to you what the problem is without explicitly saying my problem is not moving, or not being able to move storage. The rest of the patent application that I drafted is mainly reference-related material. Here I tell you the field of the invention, which as you can see is moving storage. Then I go on to federally sponsored research, which there was none, so that was not applicable. And then finally, I referenced related applications. However, I did not file a provisional patent application for this patent, and therefore that was not applicable also. And finally, there is the title page. And then the abstract. The abstract is a concise statement that helps people search for the patent. So, for example, this abstract says, a rack for moving storage. The rack is comprised of a frame and a base. The base supports the frame, and the base is capable of being moved. So it's very much like the first claim. It's just a short statement, like I said, to help search for the patent application. In order to help me draft this, I did some research. Much of my research involved learning how to draft claims. So here you can see that I researched problem-solution-based claims and then inventive departure-based claims, which are just different methods of comprising the claims. And then I researched patent quality to see what constitutes a good patent. And I learned that actually it really depends on who you're asking. For example, the article cited, or they compared large pharmaceutical companies to large technological companies who view patents differently. And this is mainly because pharmaceutical companies, it takes them decades to develop a profitable invention, whereas in big technological companies, it takes them just a matter of a few years. So for this reason, the pharmaceutical companies are going to be much more protective of their patents and view them differently as opposed to the technological companies. Lastly, I researched readers' expectations, which helped me draft the patent in the clearest, most concise manner. However, it's also going to help me with my future goals in just developing my rhetoric. And some of those future goals are mainly aimed at tying back in my love for political science. My short-term goals were mainly directed towards this mentorship. So they were focused on drafting the patent application. As you can see, in October, I focused on drafting the claims, and then I moved on to the detailed description and then the rest of it. Now my long-term goals, I'm still pursuing, and like I said, ultimately I would like to apply my legal insight to public policy, and I plan on doing that by attending civil court cases and practicing citations, learning to brief cases, and just enhancing my legal knowledge that Dr. Collada has helped me establish. And for that, I would like to thank you, Dr. Collada, for introducing me to the legal field and inspiring me to continue pursuing it and my love for political science and then tying the two together. And I would also like to thank my audience for joining me today. Thank you for your time and attention. In my few months with Dr. Collada, I have seen how demanding the intellectual property world is, so I know that time is precious, to say the least. And now, if you have any questions, I will take them.